Okay, so in the last video we discussed defense attorneys, and now we're going to get back into the different types of the different types of defense attorneys. So again, I said last slide or last recording that each state can establish their own legal aid services if they so choose to. The public defender system is the most common, and that is where they basically have a public defender's office, and anyone who qualifies to be represented by a public defender would go to that person's office, and their case is sent over there, and that public defender will represent that client based off of that they have to. There's two other types of systems. One is the assigned counsel system, and that just uses a rotating list of attorneys. So if the person says, I can't afford an attorney, and the court says, hey, we'll appoint one to you, the defendant doesn't get to pick off the list which one they want. They go in a numbering system. So if attorney number one gets assigned a case today, he moves to the bottom of the list, and he doesn't rotate back up to the top until everyone before him has had a case. And then there's the contract system, where different law firms compete in a sealed bid process for the right to earn the state contract. The downside to that is the cheapest isn't always the best. So then let's compare public defenders to private attorneys. I know many people always say, well, don't go with the public defender because they're not going to represent you very well, and you're better off to hire your own attorney. While there may be some validity to that on a case-by-case basis, just because many public defenders are new to the job and they're apathetic to their client, they don't really show them much interest. That's some of them. Research, though, shows that public defenders are just as effective at defending the indigent client as compared to the more expensive private attorneys. So then, representing their clients faithfully. So it's expected that the defense counsel will represent their clients faithfully, even if they know that that person is guilty of the crime they are representing them for. So think about the court-appointed attorney who had to represent or was helping with Dylan Roof's trial, the young man who was convicted of murder for the Charleston church shooting. While Dylan did represent himself, he still had legal counsel at the very beginning that was advising him. They couldn't agree on their defense, so he got rid of them. But a lot of times attorneys will catch a lot of flack in the news and on social media for, well, people will say things like, I can't believe so-and-so is representing that guy and he hurt these kids or he murdered so-and-so. If an attorney is court appointed, they don't get an option, and they don't get an option to be a bad attorney. An attorney could ultimately get disbarred and lose their job if they were to not faithfully and vigorously defend their client. So if any of you guys are thinking about being an attorney and you're thinking about being a criminal law defense attorney, just know that that is one of the things that you would really have to stretch out in your mind to see if that's something that you could do. I know for me personally, I would not be able to do that. If I knew someone had hurt a child or killed someone, or such in the case of Dylan Roof, who went in and killed 9 people while they were praying, I would not be able to represent him like he would be required of. So moving along, they have to attack the prosecution's case vigorously. So one of your homework assignments this week is to create a discussion board post from a defense attorney standpoint for the Leith Von Stein murder that you talked about last week. So when you do that, you're supposed to point out all the aspects of the prosecutor's case that is weak and try to raise reasonable doubt that your defendant, who will be James Upchurch, that he really committed this crime. So remember, when you're writing that, you want to vigorously challenge what the prosecution is saying. So you will refer back to your prosecution's opening statement from last week. If you have any questions with that, please don't hesitate to email me. All right, so then counseling with defendants. So sometimes it's obvious that the defendant committed the crime, and the defense attorney's job at that point is to say, okay, now I need to come up with a reason why you committed the crime. So like I said a minute ago, Roof, he started out with court-appointed attorneys, but he didn't agree with them because they said, hey, you're mentally ill. You need to tell the court that you're mentally ill, and that's what caused you to commit these murders. And Ruth said, no, I'm not mentally ill. He wrote a letter to the court and he said, I want the state to know that I am morally opposed to psychology and that psychology does nothing but label people with problems that they don't have. And he went with that. And he said, I know what I did and I did it for a reason. Then there's vigorously cross-examining the prosecution's witness. So cross-examination is when the attorney for the opposing side questions a witness on the stand in court. So it would be the same thing as a defense attorney questioning a prosecutor's witness. That would be cross-examination. Then you have defense misconduct. So sometimes evidence can't be admitted into court, such as polygraph tests, also known as lie detectors, because those results are unreliable and may not be correct. But consider where a defendant has submitted to a lie detector test administered by a local police department. And just for the purposes of this story, assume that the defendant passed the lie detector test. The test results would be interpreted to mean that the defendant was telling the truth, and this fact might not be considered exculpatory evidence. And remember, exculpatory evidence is evidence that excludes the defendant. So, however, the prosecutor decides to move forward with the prosecution anyway because they think that the polygraph test results were unreliable. But what if the defense counsel asked a police officer who was testifying for the state, my client took a lie detector test about this crime and passed, didn't he? Now, the prosecution would object to that, and the judge would sustain, meaning, hey, you can't say that. But just as the prosecutors would be guilty of committing a harmless error by backdooring inadmissible evidence, the defense would be equally guilty of backdooring that inadmissible evidence of the test results. Now, the judge would instruct the jury to disregard what they heard, but you can't really unring a bell after you have rang it. So the damage is done, and the defense attorney was sneaky in getting those results into the court. And these are just some of the games that people are playing. So then you have the discovery process, and it's based on the notion that all defendants are entitled to a fair trial. So the prosecution must take all of the evidence and the witnesses that they have that are going to help them prove their case, and they have to turn it over to the defense attorney so that the defense attorney can prepare an effective case for his client. In some areas, the defense attorneys have to send a list of witness statements to the prosecution for them to prepare for as well. So who bears the burden of proof in criminal prosecutions? I've said it before, but just so you remember, the state has to prove beyond a reasonable doubt, one, that the defendant committed the crime as charged and the crime was committed, and two, that the defendant is the one that committed that crime. So the defense, the burden's not on them, it's on the prosecution to prove that that person did the crime. And in our next video, we are going to discuss evidence. So now you should be familiar with the different types of defense attorney systems, as well as what defense misconduct is.